this subunit, we will discuss a special substitute for consideration called promissory estoppel. Let's set up the context for our discussion of promissory estoppel. Promissory estoppel will be used in situations where there is detrimental reliance on the part of the promisee, but it is not the legal detriment that the promisor was seeking, right? In other words, it isn't bargained for. So here's an example. Bob says to Mary, "Mary, I will give you a car for your birthday next month." Mary, in reliance of Bob's promise, goes out and buys a parking pass at her university. Did Mary suffer a legal detriment? Yes. Is Bob's promise supported by consideration? No. Why not? Because Bob was not seeking to induce Mary to buy a parking pass. Bob was making a gift promise. He wasn't seeking anything in exchange from Mary. Therefore, his promise is not enforceable under the doctrine of consideration because his promise was not supported by consideration. Let's look at the topics we're going to cover in this subunit on promissory estoppel. First, we're going to look at the rule in some detail. Second, we're going to look at the vague terms in the rule. Third, we're going to look at application in practice, right? Because promissory estoppel has so many vague words, it's a little bit difficult to predict what a court will do. Well, let's look at some situations where we think that a court will apply promissory estoppel to bind the promisor to its promise even though there's no consideration. And finally, we'll look at some common fact patterns that you can expect to see. All right, let's look at the rule. So there's a promise by promisor. That's pretty easy. You look for some sort of promise. Promisor should reasonably foresee that promisee will rely on the promise. And once again, this is based on the nature of the promise and the surrounding circumstances. So if you have a fact pattern, hopefully it's full of a lot of facts so that you can do analysis about whether the promisor should reasonably foresee that the promisee would rely on the promise. The promisee does, in fact, rely on the promise. Now, what type of reliance are we looking for? We're looking for some sort of actual action or forbearance on the part of the promisee. The promisee goes out and spends money. The promisee changes her position in reliance of the promise, or the promisee gives up some other opportunity in reliance of the promise. Now, we're not talking about mere psychic reliance. And what I mean by psychic reliance is I mean that it's not just, oh, I received that promise and I was really counting on that in my heart. Or I had that promise and now, shoo, that's off my mind. I can worry about something else. That's not the type of reliance we're looking for in promissory estoppel. We want to look and see that the reliance is justifiable and substantial. And sometimes a court will say this: we can only avoid injustice if we enforce the promise in this situation. All right, so there's the rule, and we can see all the vague terms. Reasonably foresee, very vague. Promisor's reliance is justifiable and substantial, a vague term. A court can only avoid injustice by enforcing the promise. All of these terms are vague, and because they're vague, it's difficult to predict what a court will do and when a court will actually use promissory estoppel to enforce a promise, even when there's no consideration supporting that promise. Let's look at a simple fact pattern, and then let's apply the common law rule of promissory estoppel to this simple fact pattern, just to give you an idea of the things you should be looking for. All right, so Bob is a wealthy man who regularly gives lavish gifts to his friends. Bob says to Mary, "Mary, I will give you a car for your birthday next month." In reliance of that promise, Mary buys a parking pass at her university. She pays $800. The parking pass is not refundable or transferable. All right, so do we have a promise by a promisor? Yes, the promise is Bob promised to give a car to Mary for her birthday next month. The promisor should reasonably foresee that the promisee would rely on the promise. Well, Bob is a wealthy man who regularly gives lavish gifts to his friends. If Mary is one of his friends, then he knows he gives lavish gifts. And he should reasonably foresee that Mary would count on that gift and go out and do something. Now, maybe Bob knows that Mary is a student at the local university and she needs a parking pass. If that fact is in the fact pattern, that's even better. That gives us more argument that Bob should reasonably foresee that Mary would rely on his promise and go out and buy a parking pass. Promisee does in fact rely on the promise. Remember, what we're looking for is some sort of actual action or forbearance on the part of the promisee. In this case, Mary did in fact rely. She actually had out-of-pocket costs. She paid $800 for a parking pass. And here you'd say, of course, that if she did not have the car, she would not need the parking pass. So she did rely on Bob's promise. Promisee's reliance is justifiable and substantial. Well, now this is a question of fact. It's a question of judgment. Is $800 substantial? That's a good question. Maybe we need more facts. I think probably $800 is substantial. Is her reliance justifiable? Well, she's a friend of Bob. She knows Bob gives gifts, and she needs a parking pass if she's going to get a car. So I think her reliance is justifiable. This element is closely related to the second element about whether promisor should reasonably foresee that promisee would rely on the promise. And finally, a court can only avoid injustice by enforcing the promise. There are a couple ways that courts apply this, but sometimes they'll say, listen, we're not going to enforce the promise and make Bob give her the car, but we might enforce the promise by requiring Bob to pay her $800. In other words, we're going to protect her reliance interest. We're not going to fully enforce Bob's promise by making him give her the car or by making him give her the value of the car. Maybe it was a $10,000 or a $20,000 car. We're not going to make Bob pay Mary $20,000. We might make him pay her $800, thereby avoiding injustice. Now, what other facts are relevant to injustice? The parking pass is not refundable or transferable. If Mary could refund the parking pass, then we don't need to enforce the promise to avoid injustice. We'll just make Mary get her $800 back from the university if she can. If the parking pass is transferable and there's a market for these, then maybe we don't need to enforce the promise to avoid injustice. Mary can just resell that parking pass on the market and get her $800 back on her own. Here's one more issue we want to consider. This is a gift promise. And remember early in the semester we talked about gift promises and activity level effect. Usually gift promises are reasonably certain, even though they are not legally binding. So we think gift promises are good. We want to encourage gift promises. If we start saying to people who make gift promises, your gift promises are legally binding, it's going to have an activity level effect, specifically a negative activity level effect. Fewer people will make gift promises. Therefore, if we use promissory estoppel to enforce this type of gift promise, it might have negative effects. It might have a negative activity level effect. So we want to think twice about using promissory estoppel to enforce gift promises. Okay, let's talk about promissory estoppel application and practice. And what I mean here is that there are so many vague terms in the rule that it's difficult to predict what a court will do. So we'll look for specific situations where we think a court will use promissory estoppel to enforce a promise, even though it's not supported by consideration. These are the three contexts, the three circumstances that we're going to look at, where the promissor's legal representative refuses to abide by the promise. We'll talk about a situation where courts will enforce promissory estoppel in a bargain context. We don't have a bargain, right? We don't have a bargain for exchange, but we kind of have a bargain context. And finally, we'll talk about situations where courts will use promissory estoppel when the promisor did not merely foresee reliance on the promisee, but actually intended to cause the promisee to engage in some sort of action or forbearance. Let's talk about situations where promissory estoppel is used when we have a legal representative of the promisor. In these situations, it's not the promisor who is refusing to honor her promise. It is the legal representative of the promisor who is refusing to honor promisor's original promise. When can this happen? Well, this might happen when the promisor is now deceased and the executor of her estate is refusing to honor her promise. Or it could happen when the promisor is now bankrupt and the trustee of the bankruptcy estate is refusing to honor the promise. Here's a simple fact pattern. Father promises daughter $2 million when she turns 30, right? We have a promise from a promisor. Daughter never goes to college and never develops skills that would make her employable. This is intended to represent her reliance on the promise, right? If the father is now deceased and he did not provide for this promise in his will, the executor of the estate will challenge this promise and will refuse to honor this promise. If we use promissory estoppel in this situation, well, it seems that it's a good fit. Why? Well, we do have a promise by a promisor. Looks like a gift promise. And we have reliance by the promisee. But if we enforce the gift promise in this situation, it won't have a negative activity level effect. Why? Because the promisor had the opportunity to refuse to honor the promise all the way up to, in this case, his death. And therefore, if promisors have the opportunity to refuse to honor the promise, and we will only enforce the promise using promissory estoppel when it is the legal representative, in this case the executor of the promisor's estate, refusing to honor the promise, then we will not have an activity level effect. We will not discourage promisors from making promises if we use promissory estoppel in this manner. All right, the second context where we would expect to see a court use promissory estoppel is the bargain context. So in this case, we have a situation where the promisee could have bargained for the promise, but just because of the circumstances and the way it came up, the promisee didn't bargain for the promise. Let's look at a common hypothetical. Oh, we'll look at two common fact patterns. One is the retirement bonus, and one is the past consideration situation. All right, let's talk about the use of promissory estoppel in the bargain context. Let's look at a famous example, the retirement bonus example. Company says to Mary, a current employee, Mary, when you retire, we will give you $500 a month for the rest of your life as a retirement bonus. And Mary, 5 years later, retires. So first, let's look at why there's no consideration in this situation. Company made a promise to Mary. They did not ask for anything in return. Even though Mary suffered a legal detriment, she was under no obligation to continue working for 5 years. Or you can say she was under no obligation to retire. We could look at either of those as a legal detriment. Even though that this is clearly a legal detriment, it wasn't bargained for. They didn't say to Mary, will you please retire? If you do, we'll give you $500 a month. Or they didn't say to Mary, if you work for the next 5 years, we'll give you $500 a month in your retirement. So we don't have consideration. The company's promise is not supported by consideration. Will the court use promissory estoppel to enforce the company's promise? Well, first, let's look at a basic application of promissory estoppel in this situation. Do we have a promise by the promisor? Yes. Do we have reliance by the promisee? We can make an argument that Mary retired, made her decision to retire based on the fact that she was going to be receiving that $500 a month. Or we can say a few years later, Mary relied on that $500 a month, and because she had that, she didn't seek other employment, part-time employment, while she was retired. So there's a very good argument that we could make that Mary actually relied on the company's promise. So now the question is, will we use promissory estoppel to enforce this promise? Remember what we're worried about in using promissory estoppel, that we will cause an activity level effect. We will discourage gift promises. But look at this situation. It's not quite the same as the pure gift promise. It's not quite the same as the promise from the father to the daughter, or the promise from Bob to Mary, I will give you a car. This is in a business context. This is in a situation where the parties could have bargained for this, where they really could have had a bargain for exchange. And think about why the company would make this promise to Mary. It is so that she will be happy at work, so she will be more productive at work. So even though it isn't phrased as a bargain, it is in the bargain context. And if we enforce this promise, we believe we won't have an activity level effect. We believe that companies in similar situations would still make similar promises to their employees, even though there's the prospect that it will be legally binding. Why do we think that they will still make these promises? Because it's in this bargain context and they want it to be legally binding. If this promise wasn't legally binding, Mary wouldn't be happy in her job, and Mary wouldn't be as productive in her job. And that's what the company was seeking in this situation. But it's hard to phrase that as a consideration, right? It's hard to phrase it. It's hard to put that in the consideration context, but it does fit well in the promissory estoppel context. Let's look at the use of promissory estoppel in the past consideration situation. Remember the past consideration situation? Well, let's look at a familiar hypothetical. We have a worker working on a demolition site, and the boss carelessly walks onto the demolition site when there's about to be an explosion, and the worker saves boss's life, but in the process, she suffers severe injuries. The boss says, I will pay you $500 a month for the rest of your life in consideration of you saving me, and 7 years later, he stops payment. Now, we talked about this in the consideration context. We said there is no consideration here. Even though the worker suffered a legal detriment, it was not bargained for. It's all about the timing. She suffered a legal detriment before the promise was made. We talked about exceptions to consideration. A court might say that this is moral consideration, but that's in a minority approach. Let's apply promissory estoppel to this situation. Do we have a promise by the boss? Yes, we have a promise. Do we have reliance by the worker? Well, we can say the worker didn't sue the boss, right? There's a potential for a lawsuit here. So that's the reliance here. Now, there is a bargain context here, even though you might not necessarily see it, right? Worker could have said to boss, listen, if you don't pay me something, I will sue you. Now, did the worker have a good claim? We don't know, possibly, but worker could have sued boss. And boss said, listen, don't sue me. I will pay $500 a month for the rest of your life. That didn't happen. It happened the other way. The boss took the initiative and said, listen, I will pay you $500 for the rest of your life. Now, the boss didn't ask for anything exchanged, but the boss could have. In this situation, we feel that the application of promissory estoppel to enforce the boss's promise will not have a negative activity level effect. Why? Because it's not the pure gift promise. It's not Bob saying to Mary, I will give you a car for your birthday. It's not the daughter saying to the father, I will give you $2 million when you turn 30. It is in a bargain context. Let's talk about situations where a court will use promissory estoppel to enforce a promise when a promisor was actually intending to induce some sort of action or forbearance on the part of the promisee, right? It's not that it's just merely foreseeable that the promisee would engage in some sort of action or forbearance, but the promisor actually intended this, right? Now, you might say, listen, if the promisor makes a promise intending to induce action or forbearance, isn't that just a unilateral contract, right? Don't we have a promise that is seeking performance? Well, remember, there is performance and then there is preparation for performance. So let's think of this as using promissory estoppel to enforce a promise when it's on the borderline of the unilateral contract situation. It's not quite the unilateral contract situation. It's where the promisor is intending to induce some sort of action or forbearance that is preparation for a later contract. And it's not the actual performance that the promisor is seeking. You're saying, wow, that's really close. It is really close. So once again, think of it as the borderline unilateral contract. Let's look at a hypothetical. Burger joint, right? A big burger franchise business. Burger joint says to Mary, we are interested in giving you a franchise, but first you will have to get some fast food experience, sell your current business, and relocate to far away city, right? So here we have a situation where Burger Joint is going to give a franchise or is contemplating giving a franchise to Mary, right? What's the performance that Burger Joint is going to seek from Mary? Well, signing a contract to buy a franchise from the franchisor. That would be the contract. That would be the performance. Here, what Burger Joint is asking Mary to do is just preparation for that. So you can see it's not quite the unilateral contract situation. So if Mary does all of these things, her argument that she performed according to, in response to Burger Joint's promise, and therefore we have a contract based on unilateral contract, is not a really solid argument. Okay? Here we have preparation for a performance of a future contract. In this situation, I think that it is likely a court will use promissory estoppel to enforce Burger Joint's promise. Okay? Not always, it's very fact specific, but you should keep your eye out for this type of fact pattern in the promissory estoppel context. Let's talk about some common fact patterns that you're going to see in promissory estoppel. The first is the promise to keep an offer open. We've seen this so many times. Remember, we said a promise to keep an offer open is not binding unless it's supported by consideration. Once we call it, once the promise to keep an offer open is supported by consideration, it's called an option contract, or it's called an irrevocable offer. Well, there are situations where there will not be consideration to keep the promise open, but the promisee will rely on the promise. So it's just promissory estoppel for promises to keep offers open. And if you look at restatement section 87.2, you don't have to memorize it, just read it. It follows the same pattern that we saw for promissory estoppel. A promise by the promisor that the promise should reasonably foresee that the promisee would rely on it, and the promisee does rely on it. So here we have some sort of promise by the promisor to keep an offer open. Promisee relies on that promise. Promisor is now bound to keep that offer open. The promisor cannot revoke that promise. It's a promissory estoppel in the promise to keep an offer open context. Here's an example. Mary says to Bob, "Bob, I know you're looking to buy Alice's land, but my land is better. I will sell you my land for $100,000. I'll keep this offer open until October 1st. So now Bob goes out and relies on Mary's promise to keep her offer open. Bob arranges financing to buy Mary's land and tells Alice that he is no longer interested in her land. Alice sells the land to someone else. So Bob has lost an opportunity. That's his reliance that's his reliance on Mary's promise to keep the offer open. So in this case, we would expect that a court might use promissory estoppel to hold Mary to her promise to keep the offer open because of Bob's reliance. The next common fact pattern is also a promise to keep an offer open, but it's in the situation of the subcontractor's bid. It doesn't change, it's just another fact pattern. Once again, it's just promissory estoppel in the case of a promise to keep an offer open that is not supported by consideration. Here's the fact pattern that you should look for. Contractor is making a bid for project X. Contractor needs a bid from subcontractor. Subcontractor submits a bid to contractor for the electrical work. Let's say the bid was for $25,000. Now, when contractor is preparing its bid to submit to the owner for project X, it will use subcontractor's electrical bid to calculate its own bid for the entire project. So here it says contractor relies on subcontractor's bid to make a bid for project X. Contractor wins the bid before contractor can officially and formally accept subcontractor's bid. Subcontractor withdraws it. In this situation, the court might use promissory estoppel to enforce, to prevent subcontractor from withdrawing its bid. Remember, the bid is just an offer. So in this case, the court might say, when you made the bid, you reasonably foresaw, you should have reasonably foreseen that the contractor would rely on your bid to make its bid for project X, and therefore you cannot withdraw your bid. Let's talk about the use of promissory estoppel in the guarantee context. Remember what a guarantee is? A guarantee is where I say to the bank, if you lend money to my friend, if you extend credit to my friend, I will guarantee it. I will be responsible for the debt if my friend does not pay. Well, usually this arises in the promise for performance context. So if the bank actually lends money to my friend, then they have accepted my offer by performance, and there's consideration. They suffered a legal detriment. So the question is, how can there be reliance on the part of the bank without performance? Well, maybe before the bank actually lends the money to my friend, they have to do some sort of preparation. They invest, they incur some substantial costs in doing a credit check, negotiating the contract with my friend. They incur costs in getting the funds that they need to lend to my friend, but they haven't actually lent the money to my friend yet. At that point, I can say, I withdraw my promise to act as guarantor. And the bank might say, well, you can't based on promissory estoppel. We have already relied on your promise to act as a guarantor, and therefore you cannot withdraw your promise to act as a guarantor.